AI, everything else.
All right, here we go. Hi, this is Curt
And Brad Pinsky,
and we're here for another edition, a holiday edition of Fire
or
Law
tradition,
Roundup,
one or the other.
and for Thanksgiving week, but it's December 25th of 2024. All right, here we go.
Oh,
All
you're getting
right.
that repeat back. Okay, so we have it's, I don't want to say long, like, our short shows are 30 minutes, our long shows are 45, but there is a lot today. This is good stuff. Some of it, as when we get to service dogs, I've been kind of waiting for, as Curt knows, although I think they totally blew it in that case. Anyway, so but let's go one by one. We've got a ton of stuff. This is everywhere from basic to really advanced. I'm really excited today. So let's start. We're going to go to Alabama, and we have a court who upheld the termination of a firefighter that was terminated in 22. That firefighters has sued and then lost, alleging race, gender, sexual orientation, religious discrimination, focus on religious, hostile work environment, and a bunch of other things. And of course, as always, retaliation. So she paints herself. This is a great toxic employee case. I mean, if there's ever a good one, this is it. And by the way, I'm giving opinions, of course, but these are based on facts that were determined by the court. All right. So as opposed to this is a complaint allegation. So here, the employee Adams alleges that she was, subject to discrimination, etc., and alleges that it ended up resulting in being singled out over having a tattoo that violated department policy. Now, if you tuned in, was it last week with the nose ring and the clear nose ring? And that was a lawsuit, not a case. That plaintiff should be watching this, because I think that goes the exact same way as this. Interesting cases to compare. But so, however, the district court took a very different view, hence why she lost. So the district court paints this picture. We've got a new firefighter who was on probationary status. She filed, while probationary, multiple complaints against colleagues and supervisors. And look, we're not saying don't do that. If it's true, that's what you do, right?
Absolutely.
But she was advised by a member not to get a new tattoo until off probation, and told the member, she was confident she could get another job if there was a problem. Just days after being disciplined for the new tattoo, which she got, she then claims, well, I'm Muslim and I want to practice Muslim religion, and I want to wear a hijab on for my uniform. The interesting thing, of course, is there were questions of her about how devout or even interested she is. She couldn't even answer what the main text of the Muslim religion is, which is the Quran, as every probably sixth grader knows. She couldn't come up with it. So the court didn't believe this excuse. So we can go a little more through it, right? She is African American. She is female. She is homosexual. No one's going to challenge you on that. She claims she had been a practicing Muslim since early 2022. But the timing is really important, right? She was, and this is why people keep notes, as Curt always says, keep notes. So she was found to be in violation of the tattoo policy on September 8th of 2022. By the way, some of the dates in here are horrible. People will see why in a minute. And as a result, her probationary period was extended 6 months to September 11th, 2022. And on September 11th,
From September, it was extended from September 11th. It should have ended on September 11th.
Oh, should have ended, right.
It's extended 6 months
March.
from where that came out.
Right. But on September 11th of 2022, and I know this comment's, I'm going to be tacked on it, but I'm going to say it anyway. She requested a religious accommodation to wear the hijab, saying she's Muslim. Just as, her last day of probation, what was supposed to be her last day of probation, just happens to fall on September 11th. And on that day, she raises an issue. In any event, I didn't know if she raised it to say, I'm going to pick something so offensive to everybody.
Oh, yeah, no, I don't think so. I think that was the date she may have been expecting to be off probation at that point. and she went to HR. She brought the complaint to HR. So I think it's just a coincidence on September 11th. But I kind of take this as almost like this. There's a lot of lessons here for a plaintiff's attorney.
Oh my God, so many.
And number one, you got to prep your witness before the deposition. And if she's holding if she has a sincerely held religious belief, which would be necessary in this case,
Right.
She should at least have some credibility and understanding of the religion that she's got this sincerely held belief. Now, here's the other part of this is, some attorneys do shotgun pleading. Okay, shotgun pleading is you throw it all against the wall. You make every possible allegation and you throw it against the wall. Other attorneys, and I know the guys that are friends of mine, I've got friends that kind of go in both directions. Okay.
I'm the other way.
Yeah, and it's very narrow. Even though you might be able to add these other things in, you want to go very, very narrow and give it your best on these things. And here's why that's important, because I think this could have come out differently if she hadn't made that religious discrimination claim. And I think that it undermined her credibility with the court.
It did. It gave the court something to focus on about her.
And so now all those allegations of discrimination and other problems that she had kind of got washed to the side because the court is like, oh, wait a minute. Now, you're claiming you have a sincerely held religious belief, but you've never been to a mosque, number one.
Didn't know what the Quran was.
And so there's a credibility which bleeds over onto her other claims, which, it shouldn't, but the reality is, people are people, judges are judges. And when they have this issue in the back of their minds, they can't somehow do the Vulcan mind erase and get rid of it. So.
Right. So one of the things I want to do with this, and we've done this a lot, so I want to go through the McDonnell-Douglas test because this court does it differently.
It does.
Focus on a different part. We always say, oh, step one, you've got it. That's easy. But not here. So let me go through really in painful detail for everybody, because this is really important. And there's some good lessons. And for those of you, which is probably many, who have progressive discipline, I want to talk about something with that too. You're going to see where this comes in. The court makes an interesting statement that I really like. I've quoted it. I put it in my always quote this in every case I ever have language. So I'll cover that. But okay, so we have a McDonnell-Douglas burden shifting framework. Our regular listeners, viewers know what this is, but it basically is the test, the starting test, so you don't get kicked out of court to see if the case is even going to survive. That's a way to phrase it. But the court goes through a three-step ping pong analysis. It starts with the employee has to prove something or establish something. The employer then is established, and then it goes back. But let me get really into detail. So step one, here, the plaintiff, this is where the court's focusing, right? Which, again, is very rare. The plaintiff has to make a prima facie showing of on the paper type showing of discrimination. And she shows that she's part of a protected class. Here, that's easy with regard to being African-American or Black, and female and homosexual, right? She got three. You didn't need the fourth, but she then throws in, and I'm a practicing Muslim. Then there you have to show she's subject to an adverse employment action like termination, suspension, discipline, that was qualified to perform the job. That usually is easy to do. I was hired. I, can meet the essential skills, which will be an issue for another case we get to with service dogs. And that the employer treated her differently than similarly situated employees outside her class, and they were treated more favorably. So that's what we're going to focus on. That's what the court focused on. Now there's two more steps, right? We have the burden with then once the plaintiff or she establishes that, then it normally just switches over to the defendant, where the defendant can rebut the presumption by offering evidence of a valid non-discriminatory reason for the disciplinary decision. They could say, look, you violated the tattoo policy, right? Example. And then it goes back, shifts back to the plaintiff, who demonstrates that that was really pretextual, right? So normally we're focusing on 2 and 3, and 3, the pretext. Here, we're going to focus, says the court, we're going to focus on the first part. And so neither party here disputed anything about female, African-American, or Black, or homosexual. The allegation was more somewhere later. But so Adams then the plaintiff was required to submit evidence of a comparator. This is where the court focused. The court, well, let me tell you what a comparator is. A comparator is somebody who's similarly situated, right, in all relevant, important respects. This is a high bar to meet to show that you treated people differently. So, for example, a male, 3 males get a tattoo right here, and they're not disciplined. A female gets a tattoo right here, and she is disciplined. That's comparators, right? That's what they're looking for. But the one thing I want to deviate a little bit as we're talking about comparators is to pull out a statement the court makes, and I love this statement. Quote, an employer is well within its rights to accord different treatment to employees who are differently situated in material respects. For example, who are engaged in different conduct, who are subject to different policies, and this is the part I'm looking at, or who have different work histories. One of the reasons, I'm a little off topic, but so important from this line, one of the things I always say is, listen, I hate progressive discipline. I do. Because I'm going to treat Curt, a 30-year veteran with a perfect employment history, the exact same way as I'm going to treat Brad, the new employee with less than a year on the job. I'm going to treat them the same for the same violation. Curt's got no bad discipline, and I just show up and I'm late for a shift. Curt's never been late for a shift. I could be terminated. He might get a written, right, or a verbal warrant, verbal counseling. Don't be late again. If we stick to a strict progressive discipline, you can't do that, right? So people always say, oh, aren't we going to get in trouble for treating people differently? No, that's what the court is saying, right? You can treat them differently based on their different work histories, which frankly, it's a good case, right? The case is a case, but that's the biggest point that I take away. I love that. So getting back to this.
Well, let me make one point here, because I don't think all of the circuit courts, and we're dealing with the federal court issue here, but not all the federal circuits apply it that strictly as the court here. Now, this is Alabama, and they're in the 11th Circuit, and it's no secret the 11th Circuit is not a very employee-friendly circuit court, or they're a pro-management type of circuit court. And they are a lot stricter. So, you want to exercise caution here. If you're a fire chief and you're in a place like California, Massachusetts, don't be saying, yeah. It's not quite the same. And again, the court, I think, very strictly applied this. Now, I think that comparator is really intended to be in the pretext on number 3.
That's what I thought, but he sticks it right at step 1.
While you were talking, I went back and I looked at the circuit court case that they cited for that, and it's Tynes versus Florida Department of Juvenile Justice, who in turn cites another 11th Circuit case, but also it's the 11th Circuit's interpretation of the U.S. Supreme Court decision in McDonnell Douglas. So
but you're right. This is normally a pretext argument to show, right? Not a prima facie burden of proof argument. The court does shift the burden, which I assume is why you picked this case, shifts the burden right to the beginning, which is very unfair to do.
I think it is. I agree. And that's the reason why I did pick it, because I thought it's a little bit outside of what you and I normally talk about, is that it's really, you think about it as tennis match, the first volley over the net that the plaintiff has is easy. It's just, okay, I'm
female,
an African-American,
I'm whatever.
I'm female, okay, but that's over. Now the department's got to show a legitimate reason. Then she has to show pretext. They're sort of saying now that as part of McDonnell Douglas, and I haven't read McDonnell Douglas in a couple of years.
Hasn't changed.
So, well, but I don't recall that 4-step process. Now, it may be there. It may be there, and it's one of those things you read over and okay.
No court has ever discussed in all the times we've been covering this. Hard to imagine.
The 11th Circuit apparently has, but you and I focus. And this is you and I focus on fire cases. So there could have been a case involving a municipal bus driver or a public works employee that we miss because we're focused on firefighters. So at any rate, usually it's an easy volley to get it over the net the first time. The fire department shows a legitimate reason, and then you have that problem.
And the pretext, and right. And so just to sum, if everyone's head spinning a little bit, the issue that the court focused on here, the comparable, you treated other comparably situated employees differently or better than the plaintiff, that's normally under step 3. Here, this court sticks it into the initial burden of the plaintiff in step 1, which is I've never seen it. And we've done hundreds of these. I've never seen a court do that. In any event, this court does it. And it doesn't really matter, frankly, when it comes up, because either way, it's getting addressed by the court. But here, the plaintiff then just can't show that the others were treated more favorably than she was, right? And she loses, but you said it. I think the reason she lost is because she wasn't credible. You can't believe what she's saying when she said, and I don't know why she needed to bait, because that's what I think it was. I don't know why she needed to bait a fire department. And again, I go back to on September 11th. Nothing wrong with being Muslim, obviously, and I don't care what date, right? But to choose that date to then make up, the court said it, make up, my words, but that's clearly what the court said, held, that she made up that she's Muslim. Why did she have to do that? And to me, she's just baiting the department. She already had female, black, gay. You don't need any more. You got a trifecta, right? Why did you need to throw in religion? So anyway, she loses. A long discussion for a lot of very interesting stuff. But the court,
the attorneys out there, always review your witnesses' testimony. Don't let them get on the stand to find out that there's a question about whether or not they have a sincerely held religious belief.
Yep. And then again, I take the one off, and yes, it's the 11th Circuit, but I like the comment that you don't have to treat all your employees exactly the same, which flies in the face of similarly situated employees. But
yeah, I think this, I wouldn't characterize it as necessarily a progressive discipline issue, but many departments have a disciplinary matrix. And when you come in late, it doesn't matter if you're a 30-year veteran or a brand new employee.
You get a point or whatever.
Penalty is the same. And I think I'm not a big fan of disciplinary matrices. I know departments need them, but you have to find a way to be able to take into account those unusual circumstances or just the difference between two employees.
All right. Okay, so now this is, this isn't a long discussion, but I think it's very interesting. We have the federal government sues Pennsylvania, sues the state of Pennsylvania over a sprinkler mandate. I'll explain this. It took me like 10 times to read through this case, over allegations over a sprinkler mandate for community homes. So in Pennsylvania, there are these group homes, right? And disabled individuals can live in these homes. And like anything else, there are codes. I mean, God bless codes. Firefighters, we should love codes. But here, these community homes, says the state, have to have a sprinkler system in them. Okay, right off the bat, every firefighter saying everybody should have a sprinkler system, right? So why not them? And of course, we know that, well, it's too expensive in every residential home to have sprinklers. And look, I don't know, are these type 1s, type 5s? I don't know how these homes are constructed, but in any event, the AG is saying that the requirement to have a sprinkler system may make the home unaffordable, go figure, and is actually discriminatory against people with these disabilities, frankly, but people in these homes, and it violates the ADA, and you're creating a burden by requiring sprinkler systems. I find this case very dangerous. I don't like it. I don't like the AG's allegations.
I don't know I don't know what the feds are thinking here.
The feds are thinking everybody is required to have sprinklers or nobody.
I can see that they're trying to say if you have a 3-story wood frame tenement with whatever, 2 apartments or whatever it may be, and it's regular families that are living there, they don't have to have sprinklers, but the same building that has, is going to fit into these, the folks with intellectual disabilities, it does. Right. And there's a retrofit required and so on and so forth. that they're saying that that's where the discrimination comes in. And it's a violation of Title VII of the Civil Rights Act of 1968, which, we usually talk about Title VII as the employment under the Civil Rights Act of 64, but it's a different Civil Rights Act, but also it violates the UCC, the Uniform Construction Code. And the Fair Housing Act versus Fire Code. That's the fundamental issue here. And
I got to tell you something. I don't know how this discriminates against individuals at all. They're not building the homes. They're being placed in the homes. They don't own the homes.
It's increasing the cost. It's increasing the cost. But yeah, it's a good. See,
my argument is we're not discriminating against them at all. We're just telling, look, it's no different than nursing homes. Why don't all nursing homes scream, say, oh my God, we got to have sprinkler systems, or we got to have 2 or 3 elevator systems. We have to have ADA. You don't build a nursing home the same way you build a home. You don't build a commercial building the same. My office has a handicapped railing in the bathroom. I don't want it to, but we have a $30,000 handicap ramp out front that I had to construct. I don't want to. I don't have to do that in my house. I have to do that here. But why can't we say there are different types of buildings? Let me go one further. Restaurants have to have Ansel systems. A regular kitchen in a normal commercial office doesn't have to have one, right? We do treat people differently. So I don't like this case. It disgusts me because I used to respond, you may too. We had multiple community facilities like this.
I still do.
And you
don't know till you get there. Sometimes
you don't know till you get there. There's people on the lawn sometimes. Sometimes we haven't found everybody, even though there's only 6 bedrooms or whatever. They wouldn't come out of their room. We couldn't get them out. Sprinkler systems are exactly for this reason. And why can't we? There should be an exception. I think there is an exception, but in any event, that's the case. I think it's a horrible case.
To me, it speaks of overregulation. And I know you could say, well, a fire code's a regulation, but I think we've got to the point where now the local government enacts one law, the federal government enacts another law, and now we're suing over regulation.
Yeah. Yes. We should be putting sprinklers everywhere. Let's start somewhere. Now, I got to tell you, all the state has to do is point to another industry that says, well, we require sprinklers here. I don't know that that's true in Pennsylvania, but if they do, they should win, because now they're not treating disabled people differently than non-disabled people.
Like you point out, make a good point. I think treating people with disabilities differently is okay as long as there's a reasonable basis for it. And now you have to show why we need to have sprinklers in this building, why they won't self-evacuate, or we're going to have delayed response. You can't assume, like in a normal house, you assume that people are going to be able to get themselves out. Parents will get kids out, but that most adults will be able to get themselves out. That's not the case here. And therefore, we need to have that additional margin of safety. And I think that's probably the code writers were thinking of that. Does it discriminate? Yeah, but there's a reasonable basis for it. Right. And why are we suing over it? Why don't you have congressional hearings or other things to really look at this? Why do you have to, have that adversarial aspect of it?
Exactly it. So, okay. Well, look, we'll see how this ends. It'll end in a settlement of some sort where they agreed to do something or whatever. I want to do this. I want to leave our service dog case for last if we can, because that's so in depth. And let's do a kind of a quicker one you added last night. We have an Iowa firefighter was just terminated, alleging a due process violation. Iowa.
Yeah. I'm sorry. Yeah. Last night was the Indiana case.
Oh, okay. Did I grab the wrong case? Terminated Iowa firefighter alleges due process violation.
That's Iowa. Yeah. We did that. That was a week ago.
Okay. Well, then let me get rid of that. Okay. We're not going to do that.
We need to do that. That's definitely one of the ones.
Okay. It's straightforward.
Do Iowa, then we'll do Indiana, then we'll do.
Okay, well, you got to get Indiana. See, this live stuff. You can't plan this. Okay, so volunteer firefighter in Iowa was terminated last year. She filed a suit on her own without an attorney, right? Which claims, which explains some failures, I guess. But they're claiming a violation of their 14th Amendment rights. 14th Amendment is the constitutional amendment which says everything, not everything, but whatever is I can't even say this.
Life, liberty, or property.
Life, liberty, property. Well, yeah, but it's a harder statement, and I'll explain why. The 14th Amendment applies the U.S. Constitution to the states, but not all of the U.S. Constitution. For example, the case I have now, the 7th Amendment, which provides a right to a jury trial, does not apply necessarily to the states. I raise this because I am making small but steady steps on getting the state of New York, or at least one court in the state of New York, I hope, to apply the 7th Amendment right to a jury trial in civil matters to New York State or to the states at all. There's only 2,500 cases which say I'm wrong. But I think I can prove them right. In any event, so the 14th Amendment applies almost all, but not all, of the constitutional amendments to the states. Here, the right not to be denied a property right, or of your property, here they allege your job, to be taken without proper due process. And you make a really interesting point, which is what I want to jump to. And anyway, it's just an allegation. This is not a court finding, but just says that I was deprived of my volunteer membership without proper process. I didn't get notice of a hearing. I didn't get a hearing. I didn't get right to a counsel. All very legitimate statements. You took this one step further, however, with the investigation, and you should comment on that, because it's the right point of this.
Yeah. Well, one of the things that I've found myself as an attorney representing firefighters in this situation is where I go with the firefighter, maybe with the union president, and we go in to meet with whomever, the city's attorney, the fire chief, and you're in a room, and is it a hearing or is it an interview?
Right.
And I've asked that question, and I get this perplexed look. I said, okay, just as a preliminary matter, is this an interview or a hearing? And they'll say, well, we're just here to get his side of the story. And I said, oh, so this is not a hearing. Well, no, we're just saying we want to get his side of the story. And I'm like, well, is it an interview or a hearing? Because an interview is an interview and a hearing is a hearing.
Like at a hearing, you'd present witnesses, cross-examine witnesses.
An interview is not a hearing.
Right.
Okay, an interview is an interview, a hearing is a hearing, but an interview is not a hearing. And then they're like, where is this? What planet did this? What law school did this? What planet was the law school that this guy went to? Right. So, but they don't understand the process. And so an interview is an opportunity for the investigators to understand what happened. But the firefighter hasn't been charged with anything. There might be allegations, but that's not charges. Charges are, you violated the rules and regulations, this paragraph, and this particular section. And now you have an opportunity to defend yourself. So it sounds like there was a confusion over that, and that they interviewed him, got his side of the story, and then said, oh yeah, but that was a hearing. Oh, that's not a hearing. That's an interview. Right. And I think that the key to determine whether or not it's a hearing or an interview is, in order to have a hearing, you have to be charged with something. You have to be facing charges, be presented with notice, and all the different trappings that go along with due process. So you have that issue. Of course, there's also the issue about whether or not he has a right to due process. That's a different issue. But assuming he does have a right to due process, we really need to clarify, just getting their side of the story does not provide them with due process, because if you got their side of the story as part of the interview, that did not constitute a hearing. So that was my point.
Yep. And that was a great point. And look, a pro se person, somebody without an attorney is, alleged all that. I mean, good job for them. Okay, so now, wow. I don't know where to begin on this.
You want me to do the Indiana? You want me to do
do Indiana?
Let's do the Indiana case. And I spent a lot of time on this one because there's a bunch of things that have happened in this particular department that I missed one of them. I missed an earlier suit. But the bottom line is, we have one of your favorite topics, an FMLA, and it gets entangled with an ADA issue. Okay. And what I'm surprised, because here in Rhode Island, we'd also have an issue with our workers' comp, or our 4519-1. Basically, when a firefighter suffers a job-related condition, whether it's psychological, whatever it may be, the equivalent of workers' comp obligates the fire department to pay, and there's restrictions and obligations on everybody's part to produce documentation and all that. So bottom line is we got a firefighter who it sounds like he went to or responded to a school shooting and thereafter suffered from, they didn't say PTSD, I'm assuming it's PTSD. Yeah. There is a law according to, or is it part of the workplace rules that he has up to a year to use FMLA leave. Now, we know that it's 12 weeks and it's not paid, okay? But apparently, at least under the allegations, he's got up to a year to use FMLA leave. And the employer is prohibited from burdening the employee's use of that leave. In other words, by making it difficult for them or putting unreasonable restrictions on them. So part of his allegations is that the city violated the FMLA by some of the things that they did in requesting additional documentation and so on. The requirements, you can speak to this in a second on the FMLA, what's required, okay? He also, very often what qualifies somebody for an FMLA leave also qualifies as a disability under the Americans with Disabilities Act, and he's also alleging a violation of the ADA for the same actions that created the FMLA violation. And there are slightly different requirements under each. You can ask for certain documentation at certain frequencies for FMLA. You can ask for certain documentation under the ADA for different things. So there's a little bit of untangling sometimes that has to happen between the FMLA and the ADA, and it can be a difficult balance for employers to get it right. But bottom line is there's apparently some allegedly defamatory comments that were made by the fire chief at the time. And they were made at least to some of the office personnel at the provider, the medical provider's facility. And by the way, about 2 years ago in 2022, another firefighter filed almost the exact same lawsuit. And that has since been settled. I wasn't able to find out what the settlement was, but the allegations were almost exactly, with one exception. The earlier suit also alleged race discrimination. The firefighter alleged that he was singled out because he's African American. That resulted in a settlement. I haven't been able to find out what the settlement is. One thing that I did glean was that the fire chief in the interim retired, and he has subsequently been elected to the city council. So now he's on the city council. And so I'm sure that that's going to, that's going to, the whole political perspective on it, may also get kind of wrapped up in it. The chief has been in the headlines, as I started searching it a couple of times. So, but we've got this really unfortunate entanglement between the FMLA, the ADA, and what you can ask for, what you can't ask for. And certainly, chiefs have got to be very cognizant of what they can and should say, and certainly implying that someone is faking or even asking, is he faking? Certainly opens the possibility of a defamation claim, which both the earlier case and this case allege defamation.
Yeah, what I would say is, listen, as a fire chief, when you get a certification from a physician as to a disability or medical condition, and normally, definitely under FMLA, but normally it's going to be the employee's own physician, it is not your right to question the diagnosis. You can't do that. There are other things you can question, but the diagnosis is not one. When we get to the service dog case in a moment, one of the things I would have questioned is, does the physician understand the essential functions of the job? And this is a normal thing. Physicians routinely say that a firefighter can perform based on a disability, sickness, illness, whatever, or can't perform the essential functions of the job. The problem that everybody always seems to miss is, what the hell are the essential functions of the job? Nobody ever seems to have a document a document, which if you belong to Curt and I must have policy service, you have this as a policy. What are the essential functions of the job? Because you cannot ask and should not ask a physician, we want your opinion as to what the essential functions of the job are, right? So if you want to challenge a physician's finding based on, are you sure they can lift 100 pounds over their head if that's required in our department, you can do that. But you can't challenge their diagnosis, right? You can, let me say it a different way. You can challenge their understanding or interpretation of the essential functions, but you can't challenge their diagnosis or interpretation or their whatever, their conclusion as to whether somebody can fulfill the essential functions. So where I normally see ADA and FMLA failures, more ADA, is have we even defined the essential functions, or are we just asking everybody's own doctor, make up whatever you think being an interior firefighter is, or a driver is, or whatever, right? Just make it up. So, and I think that's what we normally do. But you can't challenge the doctor's diagnosis unless you're a doctor. You can't challenge it. Be fair, and you shouldn't comment on it.
Yeah, and I think fire department, in my opinion, fire department should have a physician. They should have a fire department physician, and you can have the physician talk physician to physician on that kind of stuff. And as a fire chief, I mean, you know, I'm a lawyer, you're a lawyer, we're not doctors. We would like to think that we have that kind of clairvoyance as far as everything goes. But the reality is, let the doctor speak to the doctor. If there are any concerns about malingering or whatever it may be, let the doctor handle it, doctor to doctor. You know, you don't need your fingerprints on that conversation. And certainly when a fire chief starts calling a doctor and implying things, there's no good that's going to come from that.
No good. No question. No question. Okay. Service dogs. So let me say this. I want to give a little overview of the law and then, or what I think the law is. There are no cases that I have ever found that 100% address an issue where a firefighter or EMT wants to bring on their vehicle, which is what's missing here a little bit, wants to bring a service animal with them. Now, we're not talking about animals. We're talking about service animals. And let me give, for the relevance of here, two of the many points that people understand. One is you cannot ask for proof that the animal is a trained or certified service animal. How do I know that? Because federal law states it as much. So you can't ask. You can ask other questions, but you can't challenge, is that really a service animal? When somebody says it, they say it. And I know we're all thinking that's a stupid rule because everybody's buying these service animal things so they can bring their dog or cat or gerbils on a plane, right? So you can't challenge it. But the other thing is this. This is the main rule that all fire and EMS departments should talk about. The animal has to be under the control of the handler at all times. Federal regulations say that. So that means when I leave to go on a call, I cannot, one, cage my animal and leave them back home. Can't do that. Service animals needed, they got to come with me. And the law says you cannot house them basically somewhere else and have somebody else watch them. They're my animal. I watch them. You cannot say to the secretary at the fire department, oh, you watch my dog. Second thing is, under the control means under your control. They are with you. It's not, I left them in the fire truck or in the front of the ambulance seat while I'm on a call. With that background, you're going to have to help me, but I will try to summarize the allegations here. So I mean, you rarely post a 4-page long set of facts. So here we go.
And I knew you had a great interest in this one, so that was huge. Sort of number one. But I think it's worth spending the time, and that's why I included it all. Wow. Yeah. So here's what we got. So first we have them, and it's funny they miss one, but they're claiming a violation of the ADA. And the Rehab Act of 73, they always go hand in hand. They're almost virtually identical. And in the state of Maryland, the Fair Employment Practices Act and Montgomery County Code, they could have pulled out more. There are regulations, so they tie to the ADA. There are regulations about service dogs, and that's where you can't ask certain questions about the dog are located, not in the ADA. So I don't know why they didn't pull some of that in, but before we get too far in, because
Yeah.
it's one of the things I sort of sparked a little bit of nasty debate on Facebook over
No,
this. Not me, but
no.
a couple of people kind of got into it on Facebook over this. But there's a number of reasons why someone may need a service dog that aren't immediately obvious to people.
Sure.
Okay. And so I think we ought to, like, folks kind of think like it's a comfort animal or for stress or anxiety or
Yes, could be.
depression. And yes, they certainly could be. Those are
They
the,
can detect seizures before they
bingo,
happen.
seizures, diabetes, and some sort of a diabetic episode, too high,
Yeah.
too low. And there's a bunch of other conditions. We don't need to get
A lot of
into
conditions.
others, but just understand that. And I think each year there's additional areas where the ability of a dog to sense a problem is helpful. So it's not just stress. And a lot of the stuff seems to be folks thinking that it's stress, assuming that it's stress. It may be. I don't know. It didn't say, but it very well may be one of these other conditions as well.
Well, and that's what I find a little strange here that we don't know. Look, he didn't have to divulge it in the pleadings, but is going to have to divulge it. So here's what we got. We got everyone's probably saying, what the hell is going on? We have a volunteer. We have an applicant for a volunteer firefighter position with a at least partly volunteer fire department, and subjected to say, as sufficient to say that the employer is giving them a hard time about the service animal. And the reason I have a hard time quoting this, and I'm going to go through some of the things and tell you what not to do or what's okay to do, but the reason I'm having a hard time is because they're missing so many things they could have done. This is not and listen, this is an allegation. This is not facts. This is one-sided, not both sides, right? As we always say. So to me, the allegations obviously are not going to tell the right things that the department did, right? Mm-hmm. So this is very one-sided. Start with that. But there are some things which I'm a little shocked about. So for example, the plaintiff here claims that the fire department said you can't bring the dog on certain vehicles. And what the plaintiff is fighting over are non-emergency vehicles. The thing is, why does this matter, right? So that's one of the things. And they're having a hard time saying, should they be accepted or not? That's all about what this case is. Should I be accepted? Should I not? Are they penalizing me for having a service dog? Is that on failure to make reasonable accommodation, right? ADA says if you have a disability, you got to reasonably accommodate it. But the word is reasonable, not accommodate, reasonably accommodate. And under the federal law, here's my point to all these cases, it is unreasonable to allow a volunteer firefighter to violate federal law. It is unreasonable to allow a volunteer firefighter to violate federal law, of course, right? How do we allow that? Well, one, if we say he's able to take his dog on the emergency vehicle, where clearly the dog is not performing a search or fire attack or anything else with us, they would be locked in the vehicle. All right. So that's not allowed under federal law. The dog must be under your control at all times. The second part is, okay, so I'll just leave the animal in a cage back wherever at the station. That's not allowed under federal regulations. So I don't know why any of this is happening. But again, it's just what the plaintiff is painting here as what happened. It may not be what happened. In any event, the big complaint seems to be that they say, well, the service dog is not allowed at a communal table while we're eating, not allowed in the classrooms or training, things like that, can't be basically around other people. And I do have to tell you, and I've said this, but I've never seen it. But when I was chief, somebody came in and said, we want to bring a dog in, not a service dog, but it would be good for the mental health of all the firefighters. And I agreed that it would be, but I said no. And it got to the almost lawsuit where I'm being interviewed as chief. And they said, well, chief, why aren't you letting the dog in? I said, it's a long-haired dog. I said, I have other firefighters who will have allergies to these dogs. So you're going to have me allow the station to be infested with allergens, right? When I have allergic firefighters who are going to raise the same ADA issue that I just made their workplace uninhabitable because they have reactions. How do I accommodate that? I could have it cleaned all the time, or I just don't let the dog in. So I didn't let the dog in. That ended the matter. But that's my issue with the fires with dogs, right? And yes, I've had non-allergenic, short-haired, whatever, golden doodles and all these, things that are less allergenic. They're not completely, they're less allergenic, right? They're hypoallergenic, but they're not non-allergenic. So people can have reactions to them. In any event, this whole lawsuit is about what can the department allow or prohibit, and they picked out some really weird examples. So I'm questioning how true this really is, or how complete this really is. If this was all true, then the fire department should have just said, I'm sorry, you can't perform the essential functions of the job using a dog because you can't crawl in dark heat and cage your animal or leave them in the fire truck. So I don't understand this case fully, but I can't wait to see the answer and the response to it.
Well, let me throw something out. As you've been talking about it, what would happen if a department, I have no idea what Montgomery is doing, but what if in the past, they've had a person that had a stress animal, okay, for stress related, and they've allowed the animal to be crated. Now, I know federal law doesn't require it, but it doesn't prohibit it either, okay? And so now what do you do when somebody comes in and says, I want to have one? Also, you accommodated so-and-so, now you've got to accommodate me.
I mean, I guess I challenge at the first thing, because I think, and I'd have to pull it up, but I think the law says shall be under the owner's control at all time. So I don't think it's a waivable accommodation. So my argument as a lawyer would be, well, that accommodation wasn't legal. We should have done it, so we're not going to screw it up again. But assuming they could, right? This is always the problem with anything. You accommodated them. Go back to our first case, the comparables. Why did you treat that person more favorably than me? What right? It must be discriminatory. On the other hand, you could show, no, we have a pattern of not discriminating because we treated somebody favorably or correctly, if you want to argue that. So I don't know. In response to that hypothetical, I think, and at my conference coming up in April, end of March, we're having a service dog 30-minute presentation by somebody with a service dog who brings them in. Before that, I'm doing 30 minutes on this topic, and then we're going to do a mental health discussion if it's okay not to be okay, go into mental health. You'll be stressed because you just will have been presenting for about 3 hours. So, I'm not against service animals. I don't want anyone to say, Brad's against service animals, but they don't belong in the fire trucks. And since they don't belong in the fire trucks, a firefighter probably can't have one in the firehouse. I've had this issue in real life. I got to be very careful how I talk about it, where I've advised my client, the fire district, this person cannot keep bringing their dog to trainings or drills or calls because it can't stay under their control, and you're not allowed to ask somebody to watch it for you. So I just don't think they belong. I don't think it's a reasonable accommodation to allow a service animal when the only way to accommodate is to violate federal regulations. That's how I would say it.
Something else just dawned on me now. We're thinking about it. Montgomery County, I'm pretty sure they've got a federal USAR team, urban search and rescue team. Maybe not. I think they do. Obviously with canines. And even if they do, they don't, doesn't really matter. If a fire department allows, for example, arson canines or search and rescue canines to be crated and so on and accompany their firefighter handlers, might someone turn around and say, hey, then you should accommodate me on my service?
And I think it's a great comparison, but I think it's off because, one, those dogs often belong to the police department, the fire department, et cetera. They're in the right control of the handler. But two, they're not service dogs. They're not ADA service dogs.
I think they're work dogs.
They're work dogs. Right. So they're not the same as a service animal there for my disability. And the biggest part is they are always under the control. When I was at the fire academy all the time, whether teaching or taking, the arson dogs are always there.
Arson, but the firefighters, I mean, I know in Providence, we had a couple of guys that were on the FEMA team, and one in particular, a very good friend of mine, had a dog, and that dog came with them all the time. Now, we catch a run, the dog.
While as a firefighter.
Oh yeah, as a firefighter. But the
Okay.
thing is, that dog needed to be with them for every day. They trained every day, even when he was on duty at the fire department. They would train every day, and if he was to get deployed, obviously the dog would be with him, and off he'd go.
But your question goes one step further, which I don't have a good answer to yet on quick thought is, but wait a minute, if they're a firefighter, but they're also on the USAR team,
Right.
right? And the dog is only used for the USAR team, but the dog always has to be under their control, but they're a firefighter. So on their regular firefighter shifts, not deployed for USAR, they have the dog with them, which is owned by the department. Maybe that's a small thing that matters. Maybe it doesn't. But same issue then, right? Because they're not even a service dog. Well, maybe
Well, I
they
think it's
can
the
leave
Me
them
Too.
behind.
The Me Too aspect of it is if we're going to allow it and I think it makes sense on the USAR level.
Yes.
Okay. And somebody's going to say, well, if you allow him to have that tattoo, why can't I have that tattoo? You allow him to have his dog at work, why can't you allow me? And you let him go out on the trucks and leave the dog
The
crated.
case one comparable issue, right? That's the McDonnell Douglas comparable issue. It's a great thought. I think on first blush, if I have to argue that, I would say it's not a service animal, it's a work dog. And maybe I would say is, so the ADA clearly doesn't apply. It's not a disability issue, but on the similarly situated, I would say it's not similar because that dog probably doesn't have to be under your control all the time. Maybe you can cage it because it's a work dog, not a service dog. But that's my best guess. I think I'm right on that, but
You think it's going to be hard for us to even go outside the fire service to get an answer for this because you think about a school teacher or a mailman or a police officer, even police officers, that canine, well, they have accommodations for the dog in the vehicle and so on. But we cannot be taking a dog into a building that's on fire. Although I got to tell you, when I started in Providence, we had a dog and he went everywhere with us. He went I'm telling you, he was a great dog. He was in building. We was kind of a economically deprived community where I was serving. But if we get into a business, he'd come right in with us, and the people go, "How did that dog get in here?" Oh, it's okay, he's with us.
Yeah. and that's great. And once you fit the dog with SCBA and put him through mass confidence, I'm good with that. I don't know.
Yeah.
Right.
He was an old salt. He didn't wear an SCBA. Neither did anybody else either. So
as Goldfeder says, he'd be spitting snot out of his nose. Anyway,
he came back to quarters a couple of times like that, beat up.
So I look forward to see how the case is answered and to watch its progression. Unfortunately, we get these cases and it's 3 years later we find out how it turns out. But I'd like to see the other side of the story as we normally would. We should see both sides. Because I think I can't believe for a second they would say, well, you can't have them on non-emergency or some vehicles, but not others. The rules, you can't be on non-emergency vehicles, period, or emergency vehicles, period. You can't be anywhere where you have to leave, and you can't take the dog. I mean, that's the easy answer. So I don't know why this, but we'll see. And maybe as I think about it, he didn't accidentally forget to pull in the federal regs. Maybe he intentionally didn't pull them in because it would have answered these questions in ways he doesn't like. Maybe that's the answer. With that, I end.
All right. Well, that's going to wrap us up for a very long hour, but a good conversation and a good week. So best wishes to everyone here for a happy Thanksgiving. And we'll see you on the backside of the holiday after Black Friday. And
we'll all be 3 pounds heavier.
Yep, there we go. All right, well, that's going to do it for another edition of Fire Law Roundup. We'll see you all next week.